Okay, Jefferson County Court at Law number 2 is now in session. Court is in session with our arraignment docket. Our first case that we're going to call, we need to call Samuel Hayden Falk. Mr. Falk, would you please come forward? Yes. Could I get a copy of that motion which brought us in the file? Yeah, just hold on a minute. You have his okay, thank you. This is cause number 323227. You also have cause number 332425. Case is style of state of Texas versus Samuel Hayden Falk. Mr. Falk, is that your full name?
Yes, sir. Samuel Hayden.
Okay, Mr. Falk, would you please raise your right hand?
Yes, sir.
Mr. Falk, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Falk, you may put your hand down. How are you doing, Mr. Falk?
It's been a rough going. I was just in the hospital recently, a couple days in the ICU.
Okay.
So,
Well, it seem but it appears that you have recovered.
I'm feeling better. I got hit in the head by my sister. It was the terroristic one. Yeah.
Okay. Now, Mr. Falk, you are represented in cause number 323227 by Attorney Bruce Smith. Attorney Smith is appearing via Zoom. Mr. Smith, how are you doing?
Fine, Your Honor.
That's good. And the state is represented by Attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm doing well, Your Honor. Thank you.
Now, Mr. Smith has filed a motion to withdraw as counsel in your case, Mr. Falk. I have a copy of that motion here. Have you received a copy of the motion?
No, sir.
Okay, now, Mr. Falk, Mr. Bailey, would you please hand this to Mr. Falk? Mr. Falk, you can, if you have a seat at that table, you can take some time to read that motion, and then we'll call you back up.
Your Honor, I was aware that this was going to be happening.
Okay.
And I'm sorry I wasn't available to be here this last time. But I was aware that this was going to happen, and I had seeked other counsel.
Okay, so you're telling the court that when you were on notice, you're aware that Attorney Smith was filing a motion withdrawing your case. Is that correct?
Correct.
And you are not opposed to that, him withdrawing?
No, sir. No,
Okay.
sir. I was given
another
different
motion.
answers, but I was told that I had to be present in court while this was given to me in order for it to be official, in order for me to seek other counsel.
Okay, so you're not opposed to Attorney Smith withdrawing in this case?
No, sir.
Okay, all right. So, yeah, give me another one. Bring me another one. I gave him that one. Yeah, because what I'm gonna do is sign the order. So, Mr. Smith, the court is going to grant your motion to withdraw. You are no longer attorney of record for Mr. Falk, and your release of all your obligations in his case. And
Thank you.
Mr. Smith, you're free to go, and you have a blessed day.
Thank you, Your Honor.
And Mr. Falk,
Yes, sir.
you can go back and have a seat where you were sitting.
Thank
You're welcome. Next case is cause number 327550. Case is Solid State of Texas versus Jonathan Bernard Connor. Mr. Connor, would you please come forward? Mr. Connor, is your full name Jonathan Bernard Connor?
Yes, sir.
How are you doing, Mr. Connor?
I'm doing fine. How are you?
I'm doing fine. Thanks for asking. Now, Mr. Connor, your attorney of record is Attorney Wright Kimler, is that correct? And you also was scheduled for a court appearance in the criminal district court this morning, is that correct? Have you been to the criminal district court?
Yes, sir. Got used to it.
Okay, and so your attorney would like to have this case reset on the same date of your felony case. And please stand in front of our court coordinator. She's gonna reset your case. Once your case is reset, you'll be free to go and you have a blessed day.
Yes, sir. You too. Thank you.
Jonathan Connor.
They haven't put it in there in the computer yet, Judge.
And
So I'll
so,
just send Mike the.
okay, so you're free to go and she's gonna send the reset to your attorney and your bonds. Stay in contact with your attorney and your bonds. You have a blessed day. Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. Today, we have on our docket an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in County Court at Law number 2 is a misdemeanor case. Criminal cases are divided into felonies and misdemeanors. If you had a felony case, your case will be in one of our district courts. If you had a felony case, or you have 5 different categories, you have a capital murder, first degree felony, second degree felony, third degree felony, or a state jail felony. And the difference between those 5 categories is the range of punishment. In essence, not only the charges, but what your punishment could be in those cases if you're convicted. If you had a capital murder case, the range of punishment is life or death. If you had a first degree felony case, the range of punishment is 5 to 99 years to life, fine up to $10,000. If you're convicted of a second degree felony, the range of punishment is minimum 2 years to 20 years in state penitentiary, fine up to $10,000. If you were convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in state penitentiary and a fine up to $10,000. And the lowest felony is a state jail felony, and the range of punishment is 6 months to 2 years in the state jail, a fine up to $10,000. Now, the case that you have is a misdemeanor offense. Misdemeanors are divided into 3 categories. You have the Class A misdemeanor, Class B misdemeanor, and Class C misdemeanor. If you had a Class C misdemeanor, normally those cases are handled in the city court or the JP court, and the range of punishment is fine only. That simply means that you cannot be given jail time as the initial punishment. Your punishment only can be a fine only. Now, however, if you fail to pay the fine, or you fail to complete the probation if it was probated, then you can be required to sit out your fine or your probation with jail time. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is 0 days to 180 days in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. The highest misdemeanor is a class A misdemeanor, and the range of punishment is 0 days to 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, your felony cases are normally referred to as your more serious type cases, and the misdemeanors are referred to as petty offense. Does not mean that they're not serious. It just means that they're not as serious in that's why the punishment is different. You have less punishment in a misdemeanor case as opposed to a felony case. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. And the documents that has been passed out to you on the clipboard talks about one of the rights that you have, the first document. It talks about the right that you have to have an attorney to represent you. The title of that document is titled Judge's Explanation of Rights to Defendants Without Attorney. Now, as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to hire an attorney. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you desire to waive your right to have an attorney, waiving your right to have an attorney is giving up your right to have an attorney. And if you desire to give up your right to have an attorney and desire to represent yourself, you may not speak to the prosecutor. The prosecutor works for the state as assistant district attorney. We have one here in court, Attorney Lamar Johnson. You cannot speak to the prosecutor about your case unless you sign a written waiver, which means you're giving up your right to have an attorney. That's what the waiver is. Unless you sign a written waiver of your right to be represented by an attorney. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, child custody, housing and public benefits, immigration status for non-citizens, and employment. If you choose to proceed without an attorney and represent yourself, you may change your mind at any time and request counsel from the court. At the bottom of that document in bold letters, it says defendant's choice. Mark initials next to only one choice. If your desire is to hire an attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your desire is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is you want to waive your right to an attorney or give up your right to have an attorney and to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that states defendant. And then you will place today's date on that line that's titled date. And today's date is October 25th of 2022. Now, for those of you who will be waiving your right to have an attorney or giving up your right to have an attorney and desiring to represent yourself, you would have to read and sign the next document that's on the clipboard. That document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 25th day of October of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my rights to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that is your choice, you will sign your name above the line that's titled defendant, and you will place today's date above the line that's titled date, and today's date again is October 25th of 2022. The next document that you have for those of you who will be applying for a court-appointed attorney, that document is titled Jefferson County Affidavit of Indigence. And you would have to fill out everything on the first page of that document. Make sure that you do not leave anything blank where they ask for income information. If you do not have any income information, or if you do not have any, you're not receiving any benefits or do not have any assets, on the left side where it talks about income, monthly income, you put 0 on all of the lines that you do not receive, that doesn't apply to you. Now, if you receive an amount, it has to be what you are receiving per month. Now, on the left side, it asks for your expenses. You will place your expenses, for example, if you're paying rent or mortgage, or if you're required to pay your food expenses or utility expenses, or if you're receiving any type of child support, or excuse me, if you're paying child support, that would be an expense. If you are paying medical expenses or you're paying for a cell phone. Now, when they ask for transportation, that should include what you're paying each month. For example, if you're paying a car note, that's part of that. Or if you pay, and if you're paying insurance, you'll be required to put that monthly amount down as well. And if you paying for gas or car maintenance, you put that, you would add into the insurance and the car note. Okay. And then once you get to the bottom of your expenses, obviously you're gonna total it up per month where it says total. And once you get to the bottom of your income, your monthly income and assets, you're gonna total that as well. Then when you go to the next page, you're gonna on the back page, at the top, you have to read that top portion and sign your name. And then you read the bottom portions where it says unsworn statement. You have to fill that information out. And then that's all you would have to do on that document. Now, as a defendant in a criminal case, you also have other rights. One of the other rights that you have, hold on a minute. Okay, ladies and gentlemen, as a defendant in a criminal case, you not only have a right to have an attorney, you also have a right to have a trial by jury. And what a trial by jury is, what this young lady is sitting in that area over there, we call that the jury box. In that area, there'll be 6 citizens from Jefferson County who will be selected as jurors on your case. They will listen to all of the evidence and they will decide after listening to all of the evidence and after deliberating, they will decide whether or not you are guilty or not guilty of the charges. You also have a right to waive your right to have a trial by jury. And what I mean by waive your right to have a trial by jury, you're giving up your right to have a trial by jury. And by doing so, you will not have a trial by jury. However, your case will come before this court in one of 3 ways. It could come before the court by way of a trial without a jury, and a trial without a jury is by a trial with a judge only. We call that a bench trial. Now, the judge will listen to the evidence, and after listening to all of the evidence, the judge will decide whether or not you are guilty or innocent of the charges. You also have a right to waive or give up your right to have that trial by judge. And by doing so, your case will come before the judge by way of a plea bargain. It can come to the court by way of what we call an agreed plea bargain. An agreed plea bargain, first of all, means that you're in the state of Texas, you and the prosecutor have reached an agreement to settle your case. That settlement is called a plea bargain agreement. Now, once you make a plea bargain agreement with the state, then your case will come before the court. The court does not have to follow your plea bargain agreement. And if the court does not follow the plea bargain agreement, then you have a right to take your agreement back. In essence, you have a right to withdraw or take back your agreement. If the judge does follow that plea bargain agreement, and if you decide that you would like to appeal, then you have to get permission from the judge to appeal your case. You have to do that within 30 days. And if the judge gives you permission to appeal your case, then your case will go to another court. It will go up to a higher court for them to review. That higher court is located right above us. It's called the Ninth Court of Appeals. They will review your case to see whether or not your appeal should be granted. They will decide whether or not you've been wrongfully convicted or this court committed an error by convicting you. If they grant your appeal, then they can simply find you not guilty, or they can send the case back down to this court to have this court to give you a whole new trial. Now, if they deny you appeal, then you can appeal it up to a higher court than the Ninth Court of Appeals. That higher court is called the Texas Court of Criminal Appeals. They're located in Austin, Texas. It is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. Pro se petition, pro se means you'll be representing yourself, you'll be handling it without an attorney. Petition for discretionary review is you're asking the Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, to see whether or not this court committed an error by convicting you, or to determine whether or not you have been wrongfully convicted. If they grant your pro se petition for discretionary review, then they can find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. So just to recap, you have a right to have a trial by jury. And if you waive your right to have a trial by jury, you have a right to have what is called a bench trial, a trial before the judge. Now, if you waive that right as well, then your case will come before the court by way of a plea bargain. And it could come by way of an agreed plea bargain. That is an agreement that you've reached with the state. The court does not have to follow that plea bargain. If it doesn't, and if you want to appeal, you have to get the court's permission. Now, the other way that your case will come before the court is by way of an unagreed plea bargain. Unagreed means that you and the state have not been able to reach an agreement to settle your case. And so you want the judge or the court to settle your case. That is, you want the judge to assess punishment in your case. Now, then the case will come before the judge will decide what your punishment will be. Okay, now, you also have a right to have witnesses to come to court and testify in your case. They can testify for you or they can testify against you. You have a right to waive your right to have witnesses to testify, meaning that you have a right to give up your right to have witnesses. And that simply means that you will not be calling witnesses to testify in your case. It does not mean that the state or the state of Texas or the district attorney will not be calling witnesses to testify in your case because they are filed the case, so they will be calling witnesses in your case. You have a right, a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your own case. And by doing so, the state of Texas, the district attorney's office cannot force you to testify in your case. You may have heard the statement from people saying, I take the fifth. Well, that just simply means that they will not be testifying in the case. And so that's what the Fifth Amendment is. You have a right not to testify in your case. Now, you have a right to waive or give up your right to testify. And by waiving your Fifth Amendment right against self-incrimination, that means that you will be testifying in your case. Now, you also have a right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you. Now, by waiving your right, by seeing the evidence, what I mean is you have a right to see the documents, videos, tape recordings. You have a right to see witness statements. You have a right to also see if they had any instruments, any objects. You have a right to see whatever evidence that they have or that they're going to be used against you in your case. You also have a right to waive or give up your right to discovery as well, which means that you have a right to not have discovery in the case. When you say you're waiving or giving up the right, you are making sure that you're saying that you don't want to see the documents or the evidence that the state has against you. Now, as a defendant in a criminal case, basically everyone that's here who's appearing on their case, you've been arrested. That simply means that you've been arrested and you're out on bond. You're either out on what we call a cash bond, which means that you paid the full amount of the money, the cash amount of the bond to get out, or you're on a surety bond, which means that you paid a bondsman a percentage of the cash to get out, or you're on a PR bond, which is a personal recognizance bond, which means you did not have to pay any money to get out. You were released on your own recognizance. Now, every day that you spent in jail, that jail time can be counted as credit towards your punishment. So for example, let's say you're in the state is offering you 5 days in jail, and let's say you spent 5 days in jail and you have accepted the plea bargain agreement. That simply means that if you have 5 days in jail, you will not have to spend any more time in jail because the time that you spent in jail has already paid it off. I mean, the time that you spent in jail will be used as credit toward your punishment. In essence, you've already spent 5 days in jail, so you don't have to spend another 5 days in jail. Now, if they offer 7 days in jail and you spend 5 days in jail, that simply means that you would have to only do 2 more days in jail on your case because you get credit for the 5 days that you've already spent in jail. Every day that you spent in jail can go as $100 toward your fine and court costs. So for example, if you spent 5 days in jail and the court is offering, that's $500. And if the state is offering you a fine and court costs of $500, that means that you will not have to pay any money because the 5 days in jail has already paid it off. Therefore, the fine and court costs of $500 will be taxed and retired. Now, if they offer fine and court costs of $700 and you spend 5 days in jail, so you have $500 credit, that means that you would only have to pay 200 of the $700 because you already have $500 of credit towards the $700 fine and court costs. Now, if you have to pay an extra amount, say for example, the $200, you'll be required to pay it on the day that you do the plea. Now, if you cannot pay it on the day that you do the plea, then the court can allow you to pay it off in installments. That is, the court can put you on a payment plan to allow you to pay it off in monthly installments until it's paid off. Now, if you are unemployed, do not have any source of income, which means that you will not be able to pay it off even if you're put on a payment plan, then the court can convert your fine and court costs to community service. And you will be given $12.50 for every hour of community service that you do, and that $12.50 will go toward your fine and court costs. So the $12.50 for each hour, if you work an 8-hour day, that's $100 that can go towards your fine and court costs. Now, Jefferson County has a program that is for first-time offenders. It is called pretrial diversion. Now, what they will do with the pretrial diversion program for first-time offenders, they will dismiss your case and you can get it expunged from your record, which means you can get it erased, deleted, or wiped off of your criminal record. In order to qualify for that program, it has to be your first offense. It cannot be an offense involving unlawful carrying a weapon or resisting arrest, and you have to have an attorney to assist you with getting into the program. And as I said earlier, if you get into the program, the case is dismissed, you complete the program, then you can get it expunged, deleted, or wiped off from your record. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. And with the Veterans Court, only thing you have to do to qualify is to be a veteran of any one of the branches of the United States military. You get into the program, they dismiss the case, you complete the program, you can get it erased, deleted, wiped off, expunged from your record. And the only criteria, as I stated earlier, for Veterans Court is to be a veteran of any one of the branches of the United States military. Now, this court, County Court at Law number 2, has a program that I started in March of 2017, and that program is called the CSI program. CSI stands for Community Safety Initiative. What that program is, a program that's designed to address the issue of what we call recidivism. Recidivism is where individuals commit crimes over and over. So to address that, the issue of recidivism, I started the Community Safety Initiative within 100 days of taking office. In that program, we have partnerships with agencies in our community. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health center. And with the Spindletop Center, we have individuals who are they're in the jury box right now. We have Deputy Hinton and Sarah. They're here from Spindletop. They can do a private interview. Spindletop can also do an assessment and develop a treatment plan for either outpatient or inpatient treatment. Now, Deputy Hinton or Sarah both will come forward in a little bit and tell you more about that program. Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. And the local Alcohol and Drug Council has a program that is called OZAR. And with the OZAR, it stands for Outreach, Screening, Assessment, and Referral. And that program, with that program, there are individuals who will be able to come in, they can do a private screening, an assessment, and they can develop a treatment plan, either outpatient or inpatient, to deal with any issues that you have with drugs or alcohol. Now, if you are unemployed and do not have a job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. You will be trained in one of those areas that you choose, and they will assist you at getting a job or getting employment in the area that you are trained in. If you have not graduated from high school and you would like to get your GED, the CICE program has a GED program where you can get your graduate equivalency diploma. All of these programs that I just mentioned to you are free. They do not cost you anything. Only thing you have to do is have a desire to be in the program. And these programs, as I stated earlier, is designed to address the issue of recidivism. Tell people this all the time. When you come to County Court of Law Number 2, we do not have court as usual. We have unusual court. It's not because we're different, but if we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in Jefferson County, the community in which we live. In this court, we do not just arrest the problem, we address the problem. In essence, we do not just give time, we take out time so that we can meet the needs of individuals who come here that comes before this court, and so that we can make those individuals productive people. We believe that this program will make productive people, and we believe that by producing productive people, Jefferson County will be a safer place for all of us to live, work, go to school, raise our children, and to go to church. And as I said earlier, if you're interested in these programs, just let us know, and we'll be happy to provide some assistance so that you can address any needs that you have. Now, at this time, we're going to have Deputy Hinton to come forward, and Sarah. They're going to tell you something about the program that Spindletap have to offer. Deputy Hinton and Sarah.
Thank you, Your Honor.
You're welcome.
Good morning. Just today, my name is Steve Hinton. I'm a mental health deputy licensed by the state, commissioned with the Jefferson County Sheriff's Office. I'm here with my coworker, Sarah. Now, Sarah is qualified mental health professional, Spindletop. The reason we are here today is because the judge does care about every single person who comes to the bench. The judge found, and what's just to prove that those who appear in court with legal issues commonly have mental health, substance use disorders, or sometimes just a lack of community resources that help you. Our goal and our objective today is get you out of the cycle of arrest. This may be your first time being here. This may be your 10th time being here. Here's still talking. Sarah actually has a program in place where she can get you plugged into the resources that best fit your particular situation and your needs. I would also pass this out to everyone who's here today. On the back, it kind of explains a little bit about the court program and some of the advantages of taking advantage of it. But also on the front, it has a 1-800 number. If you ever find yourself in this question, call that number to get help immediately. Sarah passed out a form to you earlier when you came in. She's going to explain to you what we're going to do with that form and how it's going to help you move you forward.
So on the form that I gave you when you walked in is your demographic information that is HIPAA regulated, you have to not share with anyone else. The information that you provide, this is just a part information that we can help you. There is an option on there to write in any resources that you may be interested in and how you want to be contacted. So it's very important that you fill out each portion of this program.
So if you don't remember anything else we said today, I want you to remember this. We are here to help you. The judge is here to help you. We won't provide for you whatever needs particular in your situation you require. It's just going to take one thing, and it may be a little uncomfortable, maybe you wasn't prepared. It's going to take you to reach out with that need with us so that we can guide you and direct you in the best way. We can talk in the jury room back there. The judge allows an opportunity to talk privately with you individually. Or if you'll apply the information, a text or a call, we will call you and follow up with you and talk to you outside the courtroom if that's more comfortable for you. But that's again, that's up to you. We're here for your convenience and we provide it. Thank you. Thank you, Your Honor.
Okay, thank you, Deputy Hinton and Sarah. Now, ladies and gentlemen, the paperwork that you have in your hand if you need any assistance with filling out that paperwork, we have our court personnel who's here to assist you. And once that paperwork is filled out, we're going to pick the paperwork up, and then we're going to ask that each one of you individually will come before the court. You're going to stand on the X in front of the bench, and then we'll go through the paperwork. So at this time, the court is going to be in a short recess to give us time to assist any of you who need assistance and to pick up the paperwork for those of you who have already completed that paperwork. And then I will call you up to the bench one at a time. Now, if you need to use the restroom is right outside in the hall. The men's restroom is closer to County Court at law number 3, which is right next door to us. And the female restroom is on the other side of the hall, next to, I think it's Judge Templeton's court, which is the 172nd District Court. So at this time, this court will be in recess to give you time to finish filling out the paperwork and give us time to go through the paperwork and make a determination as to whether or not you will be given a court-appointed attorney, whether or not you want to represent yourself, or whether or not you would like to reset your case to hire an attorney. So at this time, this court will be in recess.